India Legal, stories that count.
Hello and welcome to another special readout from India Legal magazine. As you know, we are the nation's first political legal independent weekly focusing on controversial issues of national and international importance. The video readouts we present to you regularly are the editorial team's choice of the most significant stories we believe should receive close scrutiny and wide circulation. You can watch them along with the visuals or listen to them as you would a podcast. The topic for this commentary is an unusual one and rarely discussed. While there have been endless seminars and conclaves and studies on India's overcrowded prisons overflowing with people who have yet to be tried or convicted, concrete solutions are rarely spelled out. In this context, I would bring to our audience's attention to in fact, to a unique article penned for India Legal by two prominent legal luminaries. Justice Bhanwar Singh, a former judge of the High Court at Allahabad, and Dr. N.K. Bahl, who is a former district and sessions court judge and is presently professor of law at JEMTEC Law School, Greater Noida in UP. They discussed the concept of home detention as an alternative to jail and a method of rehabilitation while reserving prison space for serious offenders. Now, the Supreme Court, while rejecting the default bail application of activist Gautam Navlakha, had recommended studying the international practice of putting the accused under house arrest in deserving and suitable cases as a means to decongest prisons. Prisons in India are housing inmates more than double their capacity. In India, house arrest has its roots in Section 5 of the National Security Act 1980, wherein a person under preventive detention can be confined at any place, which obviously includes one's own house. But there is no provision for house arrest in CRPC, the Criminal Code of CRPC 1973. House arrest means that an individual is remanded to stay home during the pendency of the investigation, inquiry and trial in order to serve a punishment in lieu of jail. House arrest that is used as a method of pre-trial confinement will only last until the conclusion of the trial, generally speaking. Following it, a house arrest sentence might last depending on what crime the offender was convicted for and the amount of punishment awarded. The authors note that the types of house arrest may vary in severity according to the requirements of the court and, of course, the court order. A house arrest may be enforced usually during hours of darkness. The most serious level of house arrest is home incarceration, under which an offender is restricted to his residence 24 hours a day, 7 days a week, except for court-approved exemptions. The authors observe that to ensure its implementation, anyone on house arrest should have an appointed parole or probation officer who will monitor and supervise his activities. That's a given. The officer cannot be on duty around the clock for each and every person on house arrest. Hence, the arrestee may be compulsorily required to wear a GPS, a radio detection device, which broadcasts the person's presence and whereabouts. And this can be attached to an ankle bracelet at all times. The electronic sensor transmits a radio frequency signal to a base handset which is connected to a police station or a profit outsourced monitoring agency. If the arrestee goes too far from his home, the violation is recorded and the police notified. To discourage tampering, many ankle monitors detect attempted removal. The surveillance service may be contracted out, as I said, to private companies, and if the arrestee moves away from the house, the unit will send signals to the office or the officer in charge, and this will happen immediately. The officer will either call or verify the participant's whereabouts. The monitoring service will notify this to the arrestee's probation office. The arrestee is likely to take drugs and or drink alcohol during house arrest and enjoy his life. The author is right. It should be a condition of house arrest beyond a bond and surety bonds that the arrestee will refrain from taking drugs or drinking alcoholic substances. Certain kinds of home monitoring devices are designed actually to detect alcohol consumption by testing sweat or breathalyzers. The bracelets can detect changes in the arrestee's blood alcohol content via skin contact. Similarly, drug traces can be detected too. Now, these bracelets are available in the market and are waterproof. So the arrestee can bathe or swim while wearing the device without damaging it or interrupting its GPS tracking system. There are GPS ankle monitors with built-in microphones that can secretly listen and record conversations that are going on around the arrestee. These bracelets are battery operated and so will need charging. When the battery needs to be charged, the device vibrates until it is connected to the charger. Now, during this time, the power LED will blink red as a signal from the GPS satellites. The unit can be set to detect a bracelet within a range of 50 to 150 feet. When a bracelet comes in the range of the unit, it will send a notice to the monitoring center, which has to be staffed 24 hours a day, obviously, otherwise system won't work. And this has to be done all year round. The authors reveal that another method of ensuring house arrest compliance is through the use of automated calling services that require no human contact to check on the offender. Random calls are made to the residence of the arrestee. The arrestee's answer is recorded and compared automatically to his voice, the voice pattern. Authorities are notified only if the call is not answered or if the recorded answer does not match his voice pattern. It is usual that this is voice recognition. It often happens when you have to identify yourself with say your own private bank on the telephone. It is usual that friends and relatives will come to see the person under house arrest, but the authors recommend that friends should not be randomly allowed. Use of the telephone should also be restricted to the parole or probation officer, family, work, and those individuals approved by the parents, guardians of the arrestee, and probation officer. Exceptions may be made to allow visitors in emergent circumstances, but how can one get off house arrest? That's the question. Well, depending on the severity of the crime and criminal record of the arrestee, a competent court may allow breaks from house arrest. It's like a parole or a visitation right. The arrestee may be able to go to work, school, doctor's appointments, counseling sessions, community service, and other court-approved activities. The terms of house arrest can differ, but the program may allow them to work. The programs may also allow the convict to leave his residence during regular pre-approved times in order to carry out general household duties such as shopping. Ankle bracelets can be promoted as a humane alternative to jail in India. But who will bear the cost of the bracelet? Private companies will charge thousands of rupees a month for a surveillance device. The arrestee has to pay for the initial cost and maintenance. If the arrestee can't pay, he will likely end up behind bars. Now, this electronic monitoring may be a highly economical alternative to the cost of imprisoning offenders. The convict or under trial must be required to pay in cash for his monitoring as part of his sentence. The person under house arrest should not be allowed to remove the device. What happens if the bracelet dies, is destroyed, or mutilated by the accused? Obviously, the arrestee will be responsible, as this amounts to violation of the conditions of house arrest and beyond, and surety bonds. In order to have the bracelet removed legally, the arrestee needs to petition the court. The bracelet can be legally removed when the period of house arrest is over. Tampering with the electronic monitoring device should be made illegal, amounting to commission of an offence in accordance with the new legislation which has to be enacted. Now, if the arrestee violates the conditions of house arrest, including leaving the home without an approved reason, he should be arrested immediately and sent to jail. I mean, this is the recommendation of the authors. Home detention is an alternative to imprisonment. Its goals are both to reduce recidivism, which is creating a crime again after you're freed and doing the same crime again and again, recidivism, and to decrease the number of prisoners, thereby saving the budget of the state. It is a more humane and corrective way of sentencing. It allows eligible offenders to retain or seek employment, maintain family relationships and responsibilities, and also to attend rehabilitative programs, which are known to work when the people in charge of them are committed and compassionate. The purposes of house arrest, the purpose of house arrest is to administer a reasonable punishment, protect public safety, reserve jail space for more serious offenders, reduce the potential criminogenic effects of incarceration. That is, a lot of people who are incarcerated or jailed tend to become hardened criminals even after they are let out, and also help rehabilitate the offender, which should be the purpose of punishment. The arrestee should not get remission or time off for good conduct and behavior under the jail manual when under home confinement. See, it's a carrot and stick policy, because after all, an offender under house arrest is not a free man. There has to be certain, a free person, there have to be certain restrictions, and they have to live by the rules. Now, if the court has sentenced the person to 1 year, he has to serve that entire amount under home confinement. However, the arrestee is entitled to get the period of house arrest set off against the total sentence awarded to him under section 428 CRPC. Now, in what category of offences should a house arrest program be resorted to? The offences should not be punishable more than 7 years of imprisonment. That means a person who is not, if the offence that he is accused of or is being punished for is carries an imprisonment of 7 years or under, that person could qualify or should qualify for home confinement. Now, this facility should be available to first-time offenders only. In general, offenders such as terrorists, murderers, rapists and dacoits should not be considered eligible for house arrest. Drug peddlers and habitual offenders should also not be eligible. Likewise, offenders of immoral acts deserve to be in prison rather than under house arrest. All these antisocial offenders must not be given the comfort and facilities of home. This program would best be for juveniles and females. House arrest can be used at the under trial stage as well. That is when you're arrested for a crime, sometimes you have no lawyer and you are under judicial custody and your case just hasn't come up, the date after date, tarikh pe tarikh par diye. That's then under trial. So it should be used for the under trial stage as well as after conviction to decongest prisons. Cases for house arrest may be selected on the basis of old age, health conditions, antecedents of the accused, nature of the crime, and ability to afford and enforce the terms of the house arrest. The accused will not come in contact with other accused persons in jail. Jurisprudentially, it will be rehabilitative too. House arrest can be a cost-effective way of punishing criminals who pose no threat to others and thus do not need to be imprisoned at the state's expense. However, its feasibility will be a big question mark in India. All the above mentioned surveillance measures must be taken care of by a suitable legislation. That's absolutely essential. Otherwise, the accused will commit a crime and enjoy it home, which will be counterproductive to the criminal justice system. This article by two of our most prominent and qualified jurisprudential thinkers deserves to set the tone for any future discussions and proposals encompassing legal and prison reforms. And I am personally grateful to Judges Bhanwar Singh, with whom I have been on many panels, and N.K. Bahl for providing fresh fodder for thought. This is your host editor, Inderjit Badhwar. Until next time, goodbye for now.
India Legal, stories that count.